The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. I am Colin McDonald, ABI's Membership Program Manager, and I am pleased to welcome you to the next webinar in our ABI-Live series. Today's webinar, titled Up in Smoke, Marijuana Meets the Bankruptcy Code, is hosted by our Asset Sales Committee. Before I introduce you to today's moderator, I'd like to address a couple of housekeeping matters. ABI is offering CLE for this webinar in several jurisdictions. If you need CLE, please complete the survey that will appear on your screen immediately following the webinar. You will then receive a follow-up email this afternoon that details how to claim your credit. On the right side of your screen is a series of windows where you will receive a copy of today's PowerPoint by taking a look at the handout window. Also, if you have any questions for the panelists during the webinar, please type them in the GoToWebinar conversation box on the right-hand side of your screen. I am now pleased to introduce our moderator, Matthew Lacaze. Matthew is the Managing Director of Equity Partners in Easton, Maryland. Matthew also serves as a Special Projects Director for the Asset Sales Committee here at ABI. Welcome, Matthew.
Hi, Colin. Thanks. Hi, everyone. Thanks for joining us today for what should be an excellent conversation on a constantly evolving topic. So with that, let me introduce our panel and we can get started. Mark Salzberg is joining us from Washington, D.C., where he's a partner in the office of Squire Patton Boggs, and a member of the firm's restructuring and insolvency practice group. He focuses on bankruptcy litigation, creditors' rights, debtor reorganizations, and complex commercial litigation. Mark has extensive experience representing debtors, creditors committees, financial institutions, secured and unsecured creditors, franchisors and distributors, and bankruptcy matters throughout the U.S. He has served as the lead appellate counsel in multiple bankruptcy appeals at both the district court and bankruptcy appellate panel levels and regularly counsels clients on intellectual property matters arising under the bankruptcy code. He is a member of the Law 360 Bankruptcy Editorial Advisory Board. Unfortunately, Aaron Kahn had a last-minute conflict, so he's going to be unable to join us, but Candace and Mark are going to be doing the heavy lifting for us. Candace Carline is joining us from Las Vegas, where she is a founding member of the firm Carline Sika. Candace brings over 3 decades of experience, including representation of a myriad of constituencies in commercial reorganization and credit restructuring. Candace is a tenacious litigator representing clients in complex commercial litigation matters, including fraud, contract deficiency, business disputes, and receiverships. She also conducts mediations and serves as a pro tem short trial judge with the 8th Judicial District Court. She has been certified as a commercial bankruptcy specialist by the American Board of Certification of Bankruptcy and Creditors' Rights Specialist since 1994 and is a past president of that organization. She has been recognized in Best Lawyers in America since 1996 and has held an AV rating, the highest available since 1989. So with that, I will turn it over to Mark and Candace, and we can get started.
Great. Colin, thanks for moving the page. So this is Mark Salzberg. Colin, if you can move one more page up and we can start. Okay, so the first thing to talk about is, and please next page, Colin, is where we are in the United States when it comes to cannabis. And we're going to concentrate on cannabis today. We're not going to be talking necessarily about hemp or CBD, but right now, we have 11 states and the District of Columbia that have legalized recreational marijuana. And we added Illinois to that list effective at the beginning of this year. So 33 states and the District of Columbia have legalized medical marijuana. There's an overlap between the complete legalization and the medical use as well. But what we have here clearly is we have the majority of the states which have legalized some form of use of marijuana, but we have the federal government which obviously doesn't share that view. If you could, Colin, go to the next page, please. The tension between the state law and the federal law comes down to the Controlled Substances Act. Cannabis is a Schedule I narcotic, and the CSA criminalizes all aspects of the cannabis business. And what we have here on this slide are a number of sections of the CSA which criminalize various activities. So for instance, you have cultivators and dispensaries that would be violating Section 841A1. Also, sale of equipment, sale of product used to manufacture marijuana products, that's illegal under the CSA. You can't lease or rent space used to manufacture or distribute marijuana, and you can't manage or control any space used in the manufacturing or distribution of marijuana. So these are all aspects of the control. Hello?
And when you talk about that last one, management, this is Candace. Take a look at the word mortgagee, because that's very important. The lender is also specifically at risk for forfeiture. That's
a very good point. Thank you for adding that. And in addition to the CSA, we have potential criminal liability for aiding and abetting violations of the CSA. So that would be a federal crime under 18 U.S.C. Section 2A. So that's the federal law, which is obviously diametrically opposed to those states that have legalized some form of marijuana. Colin, if you can move to the next slide, please. So we're going to focus on Chapter 11 and talk a little bit at the end on Chapter 15. But again, at the bottom, the tension is between conflicting state law and federal law, and how that arises or comes up into play in the bankruptcy courts, especially in the Chapter 11 context, is the courts are concerned with condoning, well, really, let's call it greenlighting post-confirmation business operations that are illegal under federal law. So the courts have dismissed cases under Section 1112B1 for quote-unquote cause and for mismanagement. The courts have also found that a plan cannot be confirmed in good faith. It cannot be proposed in good faith, in violation of Section 1129A3, and that plans for cannabis companies would not be feasible because the plan would violate federal law, and that would violate Section 1129A11. Now, Candace will talk a little bit about a recent ruling in the Garvin case in the Ninth Circuit, where the Ninth Circuit gave its interpretation of 1129A3, not as applied specifically to the cannabis space, but there was some good language in that opinion, which kind of, let's say, opened the door a bit to cannabis filings, although that door might ultimately be shut. But the party that usually would shut the door, so to speak, on a cannabis company filing would be the U.S. Trustee's Office. They have been given direction by out of D.C. to carefully scrutinize cases that might have cannabis connections and to move to dismiss those cannabis cases. We had a case recently filed in Delaware where the U.S. trustee at the first day hearing, this was the debtor was involved in the nutritional side, and the U.S. trustee was very careful to ask me specifically if the business touched cannabis at all, touched CBD or hemp or anything of that nature. If in fact that was the case, there would have been a motion to dismiss that would have been filed. Very quick brief mention on Chapter 7. So obviously we all know that Chapter 7 trustees take possession and control over the assets of the debtor. And in the Chapter 7 context, the courts have been concerned that the trustees cannot administer assets that are still illegal under federal law. And for that reason, those cases have been dismissed under Section 707A, again, for cause. And a brief mention right here, and we'll talk about it a little bit in depth at the end, Chapter 15. These are cross-border cases where, with a foreign insolvency proceeding, the U.S. courts have been asked to, are asked to give recognition to those proceedings. And one can envision a foreign cannabis company filing, for instance, in Canada, where a number of the cannabis companies that are doing business in the United States are actually Canadian companies accessing the Canadian capital and being listed on the Canadian exchanges. The question there is whether or not Section 1506, which is the public policy exception, would apply to block those filings. Interestingly enough, and this is not on the slides, the tension that's in bankruptcy court is also apparent in the district courts. There have been two recent decisions of note. One case out of District of Washington, Left Coast Ventures. Another one, James versus Gantmacher, which I believe was in Nevada. I may be incorrect about that, but I'll be happy to answer that in a follow-up email if anyone has any questions. The courts in both those cases indicated that they might not be able to order specific performance of contracts that would change ownership of marijuana growers. In the Left Coast Ventures, the court said, quote, ordering specific performance in this case may require mandating illegal conduct, end quote. And in the Gantelmacher case, the court said, quote, awarding plaintiff an ownership interest in or profits from the defendant, a cannabis company, contravenes federal law. So you can see that the tension that's most apparent in the bankruptcy side is now making its way into the trial courts and the district courts, where they're showing some reluctance, excuse me, to entertaining any case where they would be giving essentially a stamp of approval to companies that are violating the Controlled Substances Act. This kind of underscores the need, if someone here is negotiating a contract for a client in the cannabis space, to think carefully about venue, because you may not be able to access the federal courts. It may be that you have to get to the state courts. Colin, if you could switch. So the question is, what's the origin of the U.S. trustee's position with respect to cannabis? And these are primarily memorandum coming from the Department of Justice that started back in 2009. The latest memorandum was 2019. The first memorandums from 2009 to 2013 provided, in essence, that the federal government would shift priorities away from prosecuting cannabis companies that were acting in compliance with the state law. 2019, then Attorney General Jeff Sessions rescinded the earlier memos and directed the federal prosecutors to weigh all relevant considerations. So kind of opened the door to prosecuting cannabis companies that were acting in compliance with the state law. More recently, Attorney General Barr said he would not go after these cannabis companies in states where cannabis is legal.
I note that in between the memos and the Sessions rescinding the memos, there was something called the FinCEN guidance, which gave federally chartered banks, guidance on when they could and couldn't take marijuana accounts and filings. And although the memorandums on which the FinCEN guidance were based have now been rescinded, that guidance is still out there. And it's on that basis that we do have some particularly state savings and loans that are doing business with marijuana companies, not a lot.
And with respect, and that's a good point, Candace, with respect to the banks, federal banks banks that are part of the federal banking system will typically not accept deposits or make loans to the cannabis companies. There's concern about money laundering issues. And the result of this is a lot of the cannabis companies are a cash business and are paying, in fact, there are anecdotal stories out there of cannabis companies paying taxes in cash. There was a recent story about a California company paying $200,000, over $200,000 of tax each quarter in cash, making arrangements with the tax collectors to meet representatives in certain places with essentially suitcases of cash. Also on the tax issues, cannabis companies cannot write off business expenses since the tax code, section 280E, classifies cannabis farmers, dispensary owners, processors, and others in the field as drug traffickers. So that's kind of
one exception. They're allowed to write off costs of goods sold, so the only write-off is the product that's illegal.
Yeah. So I think that brings us to the next page, Colin, and these are some cases of interest that we thought were subject that could be discussed. And these first cases are cases where bankruptcy relief was denied to the cannabis companies. But before we go there, Colin, I think you want to make an announcement about the CLE number.
Yes, this is the first CLE slide of this webinar. Please note it for your CLE purposes. You will need it for the survey that we will send around later on today. Thank you.
So why don't you go to the next page, Colin, and Candace, I'm going to turn it over to you.
All right. So in the early cases were pretty strict that the bankruptcy courts did not want to administer cases related to marijuana. One of the first ones is this Rent Right Super Kegs case. In this case, the debtor was not directly engaged in the business of any business related to marijuana, but at least 25% of it received 25% of its income from a warehouse lease for a marijuana grow house. And the court ended up holding that that was inappropriate in terms of bankruptcy court relief and cited a number of grounds. First, they considered the issue that the feds had indicated they were going to exercise discretion not to prosecute marijuana crimes in states where it was legal. And the court said, yeah, regardless of whether or not there's a prosecution, unless and until Congress changes the law, the operations constitute a continuing criminal violation of the Controlled Substances Act, and a federal court cannot be asked to enforce the protections of the Bankruptcy Code in aid of a debtor whose activities constitute a continuing federal crime. The court also found that it could not ask the secured creditor to take even a small risk of forfeiture based on the federal criminal forfeiture statute that we just looked at. The court found that bankruptcy courts, as courts of equity, require parties to come with clean hands, and you don't do that when you're engaged in an ongoing criminal activity. And the court also found that filing bankruptcy when you were engaged in ongoing criminal activity was bad faith. So the court also found that it engaged in an ongoing criminal activity constituted gross mismanagement of the estate. So for all of those reasons, the court found that it was appropriate to dismiss the case. The court indicated that whether it should be dismissed or converted would be the subject of a separate hearing. Ultimately, this case went through a couple of years of stipulations and motions, but eventually was dismissed. Next slide, please. So the next case is the Arenas case, and this case dealt with both Chapter 7 and Chapter 13 issues. It was a Chapter 7 filing. The U.S. trustee moved to dismiss, and the court and the debtors in response said, well, we could convert. We have the absolute right to convert. And the court said, no 7, no 13. He says that the engaging in the marijuana trade, which is a crime under federal law, amounts to cause, including a lack of good faith, that disqualifies otherwise eligible debtors from bankruptcy relief. The court found that the reorganization would be funded by profits of an ongoing criminal activity, and the Chapter 13 and the 13 trustee would necessarily have a role in administering and distributing funds derived from that criminal activity, and that could not happen. The court said, short of exposing him to physical harm, nothing could be more burdensome to the trustee's administration than requiring him to take possession, sell, and distribute marijuana assets in violation of federal criminal law. The trustee could not administer the plan without committing one or more federal crimes. For the same reasons, it would be impossible for a Chapter 7 trustee to administer the estate assets, because selling and distributing proceeds of marijuana assets would themselves constitute federal offenses. So again, the case was dismissed, could not be converted, and the court found that there was no absolute right to convert when you were not filing in good faith, which is the case here. Next slide.
All right, so this is the Way to Grow case, recent case out of the district court from the District of Colorado. And this to me is a very interesting case because you're dealing with a company, the debtors were selling indoor hydroponic and gardening related supplies. Now these supplies were sold to both cannabis and non-cannabis customers. And if you think about this issue, the cannabis space in terms of concentric circles and which circle would be entitled or barred from bankruptcy relief, you conceptually you can think of the center circle being the growers, the distributors. And as you go out from that concentric circle, I think it becomes more, it becomes a grayer area as to whether or not those other players in the space, the ones that aren't necessarily touching the leaf, so to speak, should be precluded. Now here you had a company, again, they're selling to both cannabis and non-cannabis companies. The secured creditor moved to dismiss the case. arguing that the debtors were barred from bankruptcy because their business violated the Controlled Substances Act. The bankruptcy court agreed, found that the debtors were manufacturing and distributing equipment that was used in the cannabis business, and therefore violated the CSA. So the bankruptcy court dismissed the case for cause under 1112B. Now, on appeal, the district court framed the issue in two parts. One, the availability of bankruptcy protections to debtors that depend on the marijuana business, and two, whether the debtors in this case ran such a business. The district court ultimately affirmed the dismissal of the bankruptcy case, and the court said that a debtor whose plan relies on income from actions that violate the CSA does not meet the good faith requirements of 1129A3, and therefore the case should be dismissed. Now, we're going to talk about the Garvin opinion. This is the second time we mention it. It's the Ninth Circuit opinion, the only circuit-level opinion on these issues, and the rather narrow interpretation that court gave of 1129A3. The district court in Way to Grow, which came out after Garvin, criticized Garvin, or let's be polite, questioned the Garvin decision and the narrow interpretation. So one could look at the Way to Grow case as a troubling case in the sense of you have a company here that needs bankruptcy protection. They're selling to both cannabis companies as well as non-cannabis companies, so why should they be precluded from bankruptcy relief? The district court, I think, overcame that conflict by noting that a substantial majority, if not up to, I think at one point there was some discussion about 90% of the business was selling to cannabis companies, but the district court got over that tension by relying on the finding that there was at least a substantial amount of business from the cannabis space. The next page, actually, let's go to the following page. Thanks, Colin. Is the Basra opinion. One more page, please. There you go. So this is a bankruptcy case subsequent, I believe, to Way to Grow, Eastern District of Michigan. And here the debtor was a manufacturer of cabinets. The court, which by itself, obviously there are no cannabis issues, but the court dismissed the case for cause, finding that the purpose of the case was to allow the debtor's principal to enter the cannabis business in violation of the Controlled Substances Act. Here again, the bankruptcy court criticized the Garvin decision. So this is the second post-Garvin decision that at least questioned or criticized the Ninth Circuit's rationale.
Next slide.
Yes, thank you. But what's most important, I think, about this case is the discussion that the court had regarding dismissal or conversion. So the question, after the court had found cause, the question was, should the case be converted or just dismissed? And this case, the court found that conversion was untenable because it would have led to a motion being brought by the state licensed cannabis company that was using the leased space. That was an issue in the case. And the bankruptcy court held that it could not have granted that motion because that would in essence be supporting a continuing violation of the Controlled Substances Act. So because the court found that a conversion would lead to a motion for stay relief, which the court could not grant because to do so would be to essentially facilitate a continuing violation or another violation of the CSA, the court ultimately dismissed the case. So there you have a bankruptcy court that would not assist either the debtor or creditor whose businesses violated the Controlled Substances Act. And this is analogous to the two district court cases we talked about at the beginning, Left Coast Ventures and Gantmacher, where the courts refused to enforce specific performance of a contract that would change the ownership of a cannabis company. So I think those three cases are in line with each other. One case which is not in the slides I think bears mentioning, but it's an interesting case where the bankruptcy court refused to allow a debtor, a cannabis company to be a debtor. But this was in the context of an involuntary case. This is MedPoint Management, a bankruptcy case out of the District of Arizona in 2012. The involuntary case was filed against a company whose sole income came from the trademark license to a cannabis dispensary. The debtor itself argued that it was not eligible for bankruptcy because its business violated the CSA, and the Chapter 7 trustee would have to violate the CSA since the only assets, or primary assets, were the income being generated through the licensing of a trademark to a cannabis company. And so the involuntary petition was ultimately dismissed by the bankruptcy court. So you see, this prohibition can work both ways. The cannabis companies, most of the courts will restrict the ability of a cannabis company to file bankruptcy petitions themselves, but to the extent a cannabis company is having financial difficulties and which leads to the imposition of a involuntary bankruptcy, that same argument could be used by the alleged debtor to have the involuntary bankruptcy case dismissed. I think we're done with that slide. So why don't we go on to part 3? Candace, did you have, Colin, you want to talk about CLA?
Hello, everyone. This is the second of 4 CLE codes you will need for CLA recording purposes today. Please note the code and for recording purposes, and we will continue. Thank you.
Thanks, and we can move forward to the North Bay Wellness slide. This is a similar case with a different conclusion. In North Bay Wellness, the debtor, Chapter 7 debtor, was an attorney who had been on the board of a medical marijuana company, had been their counsel on a monthly retainer, and had taken client trust fund possession of a $25,000 fund that the company set up to represent anyone who was arrested, their employees, vendors, or customers, in connection with their marijuana business. The bankruptcy court held a hearing on an objection to discharge based on that embezzlement of client trust funds and said, I cannot give you relief because you, plaintiff, are a marijuana company and you're trying to get back money that is the product of your illegal activities. The Ninth Circuit reversed and said that the unclean hands doctrine, which is essentially what was at issue, requires a balancing. And even if you're a bad plaintiff, if you're a worse defendant, the court should grant you relief. They cited in footnote 6 to a Seventh Circuit case, In re Rose, where the Seventh Circuit held that the unclean hands doctrines did not prevent the plaintiff from enforcing a judgment requiring the return of stolen funds, even though the stolen funds maybe have been acquired through illegal drug sales. So we don't really think of people saying, hey, he stole my illegal drug money. But here the Ninth Circuit said, if your attorney steals your illegal drug money, you ought to be able to get a judgment of non-dischargeability. Next slide. The Johnson case is out of Michigan, and this represents something other than an automatic dismissal of a case where the debtor is involved in the marijuana business. The case starts out with the statement, the country's relationship with marijuana is changing, and one person's pusher is another's caregiver. This debtor lived half on Social Security and half on the proceeds of cultivating marijuana plants primarily for medical marijuana patients, and was a licensed caregiver and able to do so. The court found that because federal judicial officers take an oath to uphold federal law, the court could not provide continuing protection to the debtor if he continued to engage in illegal activities. But the court said the debtor would have a choice, either give up the pot or give up the bankruptcy. And if the debtor chose to exit the marijuana business, the court would permit the bankruptcy to go forward, but the debtor would be required to the court issued an order abandoning the plants and would require the debtor to destroy the plants, I think probably by fire. And so that was really kind of an opening. It's a case that's not even within the Ninth Circuit that says the fact that you were engaged in that business on the petition date is not determinative of whether you might be able to get relief. Next slide, please. The Olson case is out of the Ninth Circuit, as are a lot of these cases that we're going to talk about that seem to open the door a little bit. And you can tell a lot about the case by how it starts out. And in this case, the opinion starts out, the debtor is 92 years old, legally blind, and resides in an assisted living facility. So I wasn't shocked to find out that the court said, maybe we're not going to dismiss her bankruptcy because of the presence of marijuana near the case. Here, the debtor was the principal of an entity that leased property, and one of the tenants was in the marijuana business. And she said that I didn't knowingly rent to these marijuana people. I had a relative that was really managing the property. All I want to do is to get rid of the marijuana business and go through and complete my Chapter 13 plan. The bankruptcy court had dismissed the case, and the BAP reversed and held that under the circumstances of this case, there was not a showing that the debtor had knowingly and intentionally allowed its property to be used for the purpose of distributing drugs, and reversed the bankruptcy court dismissal. Next slide is Garvin.
Candace, if I could. Yeah, yes, one thing, there's an interesting tension between a case like Olson, where the court looked at the underlying circumstances and maybe even felt bad for the debtor, versus a case like Andrick, which is a bankruptcy case out of District of Colorado, a Chapter 13 case, where the debtors were husband and wife, and the question was, what were the debtors proposing in their Chapter 13 plan, utilizing all of their disposable income? And the wife was spending approximately $900 a month on medical marijuana that was required for health reasons. And the court found that you could not, or the debtors could not, carve out the $900 for medical marijuana, even though it was legal in Colorado, because it violated federal law. And with the extra $900, their creditors would get paid, I think it was 100 cents on the dollar versus approximately 30 cents on the dollar over time under their plan. But there, the equities of the case really, if you read the facts of the case, the equities would say the court's got to find a way to allow these debtors that are in a horrible financial situation to reorganize their affairs. But the equity didn't really, it didn't matter in the case.
Yeah, that's exactly right. And I think, and we'll come to some other cases that talk about there's a bright line test, there's not a bright line test. In my opinion, there is not. The circumstances of the cases really do impact the outcome. So if we could move on to the next slide. The Garvin case, which Mark has set up for us to discuss, is a Ninth Circuit case decided last year, where the issue was confirmation of a plan whether the debtor derived lease income from a tenant in the business of growing marijuana. And this case is interesting because the U.S. trustee had moved at the beginning to dismiss the case for gross mismanagement. And the bankruptcy court said, I'm going to deny the motion right now, but you can renew it at confirmation. Went through the confirmation hearing. The U.S. trustee objected to confirmation under 1129A3, but didn't specifically say, and I'm renewing my motion to dismiss for gross mismanagement. On appeal, the court held that Section 1123, which requires that a plan be proposed in good faith and not by any means forbidden by law, did not mean that the plan could not be funded with the proceeds of an illegal enterprise. And the same statutory language appears in Chapter 13 under 1325A3. The court found that the phrase proposed by any means only went to the proposal of the plan and not to the actual implementation of the plan. The proposal looks at, did you propose a plan for a good reason? Did you not solicit votes without getting a disclosure statement approved, etc.? So this is, in my opinion, really one of the strongest cases for staying in a Chapter 11 if you have some connection to the marijuana industry. But interestingly, and this was pointed out in one of the prior slides, the Ninth Circuit held that the gross mismanagement issue was not before it because the U.S. trustee had failed to renew its motion, and therefore that issue was not appropriately raised on appeal. Next slide.
And I think, and Candace, very quickly, I think sure. Garvin is kind of a warning to the U.S. Trustee's office all around the country that when they have a cannabis case, bring your motion to dismiss. If it gets denied or continue to a later date, make sure that you bring it again, because the outcome, I think the outcome of the case could have been different and probably would have been different if the U.S. Trustee's Office had renewed its motion to dismiss.
Yeah, and maybe not. I mean, the other thing to realize is I think this was a 100% plan. And the U.S. trustee, as you said, is charged with coming in all of these cases and moving to dismiss. But more and more, the parties don't want to prosecute such a motion. And so I think some of the courts and some of the circumstances are looking for reasons that case might be able to stay in bankruptcy. Going back to the Olson case just a minute, I also wanted to note that one of the issues was the bankruptcy judge's knee-jerk reaction. The word marijuana is here, the case has to be dismissed. And the bankruptcy appellate panel instructed that when you're dealing with this kind of motions, you actually have to perform a statutory analysis. The word marijuana does not mean dismissal. You have to actually go through the basis of the motion and what the showing is and how it applies to that specific case. So the next case is actually, it's a local case here in Las Vegas. It's CW Nevada, if we could, yeah. And in that case, it was a very long decision written by the court, 62 footnotes. It ultimately held that, while there may be a time when we can have a marijuana, and this was an actual marijuana business, be eligible for bankruptcy relief, this is not that time. But the interesting thing is a footnote in the case that said, there are 8,700 residents of Nevada employed by the marijuana industry. The impact of automatically denying a bankruptcy fresh start to those residents and their dependents would be unconscionable. So that's, to me, almost a sea change in how a bankruptcy court is looking at the issue, saying it would be unconscionable to not let an individual employed in a marijuana business to obtain bankruptcy relief. I do want to talk about one more case that's not in the slides because it's so new. It's the Burton case. The citation is 2020 Westlaw 208803, decided January 14th of this year by the bankruptcy appellate panels of the Ninth Circuit. And this case kind of attempts to reconcile some of the Ninth Circuit cases. Here, the debtors owned a majority interest in an entity that had been engaged in cultivating and selling marijuana. The debtors claimed that that business was no longer operating, but they were the plaintiffs in litigation seeking to obtain a recovery based on when that business was operating. The issue was whether the case should be dismissed, and the bankruptcy court entered an order dismissing the case. On appeal, the BAP said they attempted to draw together a number of different cases to see what the principles were that were in play, and said one principle seems implicit in the case law. The mere presence of marijuana near a bankruptcy case does not automatically prohibit a debtor from bankruptcy relief. They cited to Olson and North Bay Wellness, as well as to Govan, but that's something that could be of help if you're involved in a case, that this is, at least to the BAP, one bright line, that there's not an automatic dismissal if there is marijuana near a bankruptcy case. The BAP then said several courts have held and went through and tried to group the different cases together and see what principles they could come up with. The next, they said that several bankruptcy courts have held that a case must be dismissed if the continuation of the case would require the court, trustee, or debtor in possession to administer assets that are illegal under the Controlled Substances Act or constitute proceeds of activity criminalized by the CSA. The court found that some courts have held that a bankruptcy filing or plan of reorganization proposed by a debtor who is involved in an illegal enterprise is not in good faith, even whether the debtor does not have a subjective bad faith motive and is in legitimate need of bankruptcy relief. Some courts have concluded that a debtor engaged in illegal business who seeks bankruptcy relief come into court with unclean hands and is not eligible for relief. The reported decisions illustrate that the nature and extent of debtors' involvement in the marijuana business can vary widely. And the court concluded that the bankruptcy courts appropriately have wide latitude to deal with these variations. So, the court held that under the circumstances of this case, the bankruptcy court did not err in its finding or abuse its discretion in finding that the ownership interest in both the company that had been in the business and more particularly in the litigation that was seeking to bring into the estate proceeds of that business constituted cause for dismissal. And so while Burton represents a case where dismissal was upheld, the court also said that there's not a bright line that says you can or cannot be in bankruptcy if you are engaged in or were engaged in marijuana activities or received their proceeds. So in this case, there were a number of other factors. There was a $2.4 million unsecured claim, which is a little bit inconsistent with being eligible for Chapter 13 relief. The case had been pending for a year without any confirmable plan being proposed. And the debtors apparently owned interest in a lot of other businesses, some of which appeared to be ongoing marijuana businesses that they really hadn't told the truth about or disclosed appropriately. So there were a lot of reasons why that case was dismissed. But the case is interesting for its analysis of, number one, there's not a per se dismissal rule when you hear the word marijuana. And number two, the bankruptcy courts themselves have a lot of leeway in determining what to do in a particular case.
And Candace, I think that case is great because the challenge in the cannabis cases is most courts or a lot of courts would think there is in fact a bright line rule. As soon as the word cannabis comes up, that means the case needs to be dismissed or converted, most likely dismissed. So right. a case which says rejects that bright line rule is very helpful.
And again, the Olson case, I think this the same thing.
Yes.
The concurring opinion especially just talks about the fact that you need to go through the analysis. You can't just have a knee-jerk reaction cases dismissed, which a lot of bankruptcy courts have had. So let's talk about alternatives to bankruptcy, if we could move to the next slide. Even better, let's have Mark talk about it. But first, record this number for CLE purposes.
Hi, yes, this is the third CLE code you will need for CLE purposes. The number is 67890. Again, that number is 67890. And before we move on to the next slide, Candace, we have had a couple of requests for the citation of the case you had mentioned that was not in the materials. If you wouldn't mind sharing that with everyone.
No, this is the Burton case, and the citation is 2020 Westlaw 208803. It's a Ninth Circuit BAP case decided January 14th, 2020. 2020 Westlaw 208803.
Okay, so part 4, we're talking about alternatives. So bankruptcy, if there is a bright line rule, or even if the courts are reluctant to open the door to the bankruptcies to cannabis companies, what can cannabis companies do? Or what can their creditors do? Essentially, we're talking about state law remedies. So the first one is the typical receivership, where creditors or shareholders can seek the appointment of a receiver. The receiver would take control of the property and then perhaps run the business, operate the business, and start a sale process. The trick here, or really not a trick, the problem here is a license. States require distributors, sellers, growers, et cetera, to have a license. So can a receiver actually touch the plant? Can the receiver operate a growing business or a distribution business without that license? Typically, the answer is going to be no. At least 2 states actually build into their law the ability of a receiver to at least operate the business on a temporary basis and to actually continue to sell the product. That's Oregon as well as Washington. But the other states are silent on that. So I think a state court receivership in a state that does not have a rule that explicitly allows a receiver to operate a cannabis business, it's a potential issue. Same thing with the assignment.
I apologize for the interruption. And here in Nevada, we're one of those states that don't have an explicit rule, but there is, but we do have receivers that have obtained licenses from the state and are available to run marijuana companies. And I represent one of them currently in such a case. So if anyone has that issue and wants to see how we handle it here, feel free to reach out to me directly.
All right. The next state law remedy is the assignment for the benefit of creditors, an ABC proceeding that we all are aware of. There, the assets are assigned to an assignee. Again, you're going to run into the same licensing issues. Perhaps Oregon, Washington, perhaps Nevada would allow a workaround of the fact that the assignee is not going to have a license, but you're going to have that same issue in any other state. If you could, Colin, next slide. And again, you have Article 9 sale available to secured creditors. I think you're going to have the same issue. Can the secured creditor actually recover the assets and sell the assets if the assets is cannabis, cannabis-related product? So you're going to have, in all these state law remedies, these aren't issue-free. You're still going to be dealing with similar issues. Colin, next slide. So I want to talk a little bit about Chapter 15. As we talked about at the beginning, Chapter 15 is a mechanism by which the U.S. courts can recognize and enforce foreign insolvency proceedings. And the Chapter 15 could be used to support an insolvency proceeding instituted outside the U.S. by cannabis companies with affiliates or operations in the U.S. And a lot, as I mentioned,
in say Canada, where cannabis is legal on a nationwide level.
Yes. So there are a number of companies. I think a perfect example is MedMen, if I'm not mistaken. They are incorporated in Canada. They're on the Canadian Stock Exchange. Most of their operations, their assets, are in the U.S. So the question is, could a company like MedMen or some similarly situated company that's in need of restructuring use Chapter 15 to restructure in the U.S.? And by the way, if you look at the Canadian market, to the extent that these companies are operating on both sides of the border, the Canadian market is actually restructuring, in the midst of restructuring now. Those courts are open to cannabis companies, and there is a thriving black market in Canada where the price for the product is much, much, much lower than buying it from a licensed seller. So Canada is a great case study in terms of what could happen, what likely will happen as more and more players get into the market, and to the extent that there still exists a black market for the product.
And that is a little surprising to me because legalized cannabis is so much cheaper in Canada than it is here. I mean, it's literally like 3 joints for $8, which is much less than they're selling for in the U.S. in legalized cannabis dispensaries.
Yep. So the Chapter 15 case, the question is, if you had a Canadian, let's just use Canada as an example, if you had a Canadian cannabis company that filed a proceeding in Canada and sought to have it recognized by Chapter 15, what can we expect in such a situation? I think the reasonable expectation is the U.S. Trustee's Office is certain to object. There is a provision of Chapter 15, Section 1506, which is commonly referred to as the public policy exception, which says nothing in this chapter prevents the court from refusing to take an action governed by this chapter if the action would be manifestly contrary to the public policy of the U.S. Manifestly contrary to the public policy of the U.S. Now, that public policy exception is typically narrowly construed. It's not enough that there's a conflict between the foreign and U.S. laws, and deference to the foreign proceedings should be entitled to deference if there is procedural due process. And the U.S. courts should not refuse to take an action. Should refuse to take an action only where it would severely impinge a U.S. constitutional right. The question here is the Controlled Substances Act and the federal government's interest in enforcing that act, does that rise to the level of a Section 1506 exception? At this point, we don't know the answer to it. I think it's clear that such an action will happen, and probably sometime in the near future. And this will be like the Garvin case, perhaps, one way to push the doors open in the U.S. for cannabis bankruptcy. It's just an uncertain, we don't have a test case yet, so it's uncertain how a Chapter 15 would come out. Let's go to the next page. And pending legislation, next page please, there are two acts that I think everyone should be aware of. One is the States Act, the other one is the SAFE Act. The States Act is the strengthening the 10th Amendment through Entrusting States Act, which would amend the CSA to exempt from federal enforcement individuals and companies acting in compliance with state laws on cannabis. So essentially, if you're complying with a state or tribal cannabis law, you would not be prosecuted under the CSA. And this would open banking for state licensed marijuana companies. Next page, please. And then we also have the SAFE Act, which is the Secure and Fair Enforcement Act, which would open banking and insurance to cannabis companies. This act passed the House last year, 4 months ago. Unclear as to what is going to happen in the Senate.
I guess they're a little busy with something right now.
A little something, starting in 4 minutes, actually. But even if both of these acts become law, bankruptcy is not necessarily, I think the only way that bankruptcy is cleanly open is an amendment of the CSA such that marijuana is delisted on Schedule 1. That is really the linchpin to opening the bankruptcy courts to cannabis filings.
Yeah, well, and I think the States Act might get you there because it basically says you're not on Schedule 1 to the extent that you're in a state where it's legal. Remember, Schedule 1 is heroin. So whenever you're talking about whether this is okay or not, just substitute the word heroin for marijuana and think about if it's okay to be a landlord in a case where you're funding the case with sale of heroin, and you'll come up with a pretty clear answer. But while I'm on my soapbox, well, since we have just a minute left, to me, the whole idea that these early cases took, that you have to dismiss a case if the debtor receives proceeds or there's proceeds in the estate that come from an illegal activity, is contrary to everything we know about bankruptcy. Section 109 tells you who can be a debtor. It doesn't say if you have engaged in criminal activity, you can't be a debtor. In fact, we have all been involved in a lot of cases where the debtor has been or is engaged in criminal activity. A lot of debtors file for bankruptcy because they're involved in tax issues. They haven't paid their taxes. They have, many of them, criminal issues with regard to their taxes. Enron is a great example of a debtor that was engaged in criminal activity, and the proceeds of that activity were administered in the Enron case. We've all had cases involving Ponzi schemes and investor fraud and just fraud in general. And in all of those cases, those debtors are not eligible for relief. Certainly, different issues are posed when a debtor is saying, I am going to boldly continue in an enterprise which is illegal under federal law. But I just think that the word marijuana makes people act differently than they do in any other case involving criminal activity. I mean, we've had Chapter 7 people who are drug dealers, who steal cable in violation of the law, who are prostitutes, and none of them are thrown out of court because they engaged in criminal activity. 109 does not have that requirement.
That's a very good point. And when you look at especially on the individual level, the Chapter 7 and the Chapter 13 cases, and you talk about the equities of the cases, barring these individuals who are in severe need of financial restructuring or bankruptcy assistance, barring these people from the bankruptcy courts because of their ties to cannabis, it doesn't, for lack of a better expression, it doesn't feel right. And this blanket prohibition, what some courts see as a blanket prohibition of cannabis, doesn't get you to the right result in many cases.
And this is especially troublesome to me when you're dealing with proceeds rather than the direct business, because every single person somehow has proceeds of marijuana businesses. Marijuana businesses pay federal taxes, so bankruptcy judges' salaries are funded in part by the proceeds of marijuana businesses. Marijuana businesses pay money to utilities and security firms and billboard firms, and all of those monies go into the system, and it may be once removed or twice removed, but they're there, and we all have money in our bank account that represents, in some sense, those proceeds. We have just a couple minutes. Do we have any questions? Colin, were there any questions?
Yes, there were. I had
Okay,
emailed
I should
them.
go look at my email.
While they get the questions ready, just please note this last CLE code. It's 24680. That's 24680. You will need it for recording purposes for your CLEs for the survey that will come out at the end of this webinar. Thanks again.
Okay,
So,
Mark,
Colin,
do you have the questions up? You want to field
Yeah,
the first
so
one?
the first question was whether or not there are any cases interpreting a petition for recognition of a foreign proceeding under Chapter 15. I'm not aware of any. Candace, are you?
No, I am not.
And
the
that's
next
why,
question is, go ahead.
well, very quickly, I think that's really, Chapter 15 is at the forefront of the next round of developments in this area, because it's clear that there are companies operating in the U.S. that are incorporated in Canada, so that lay the groundwork for Chapter 15 filing. And as this industry the industry runs into rough patches or needs to consolidate, I think that there will be a Chapter 15 filing sometime, somewhere.
The next question is, can you clarify the status of hemp and CBD after recent amendments? Hemp is now legal. I do not think that there's going to be an issue reorganizing businesses that are strictly hemp. And then the final note is,
well, I'm sorry, Candace, very quickly.
We're just over time, so I'm just going to read the bottom one.
Okay, just very quickly, the hemp and CBD, well, hemp became legal under an amendment to the Farm Act last year. And there are cases out there are some bankruptcy cases out there that have denied relief to hemp companies. But in those cases, they predated the Farm Act, the amendment last year. But in other cases, there were violations of other laws governing hemp. So, for instance, or CBD produced from hemp. CBD might have been added to drinks, and that violated a different act, and I forget the name of the act. But those, so you're dealing with different violations of federal law. But there are some cases out there indicating that hemp and CBD companies could file, some cases saying they couldn't.
And then finally, thank you for the person who wrote in that Oklahoma has an express statute governing marijuana business receiverships, which is 12 Oklahoma statutes 1560, which just became effective last November 1st. Thank you all very much.
Any other questions or?
All right.
All right.
Well,
Thank you to the ABI and the Asset Sales Committee. We've had tremendous response to this webinar. It's been a pleasure.
all right. Thanks, Candace. I also just want to say once again, thank you to our wonderful panelists for their time and insights today. And thank you to the Asset Sales Committee for hosting the webinar today. As a reminder, for those of you wishing to claim CLE credit, please remember to complete the survey that will pop up on your screen and look for the instructions in an email later on today from GoToWebinar. On a special note, ABI will be holding a webinar on Tuesday, February 11th on SBRA titled The Last Word on SBRA, led by several members of the ABI Chapter 11 Commission who originally championed the SME reform. The panel will help you prepare for the new law, which takes effect on February 19th. Thank you again for attending our ABI-Live program today. And once again, thank you to our speakers, and have a great week. Take care, everyone.
Thank you.
Thank you.